session held by PIBC. So it's very exciting for us all to be getting going on this whole thing. It's an exciting time in planning. So hopefully this will be a great time for some presentations and some discussions, and should be a good time. We have free food and drinks, so we're already off to a good start. Sorry, everyone at home. Excellent. So I am Sarah Fawkes-Watson. I am a PIBC board member. I am the candidate member representative, and I'll be the MC for this afternoon. I'm also joined by a few other people in the room. So we have Dave Crossley, the PIBC Executive Director. We have Cleo Corbett, she's a fellow board member, and there's a couple scattered in the crowd with you as well. We have David Block and Louis Carvello and Kenna Jonkman as well at the back. Okay, excellent. And then we are also going to have our presenters as well. So a bit later on, we'll have Deepa Chandran and also Guy Patterson. Okay, excellent. So just before we launch into everything, I do just want to quickly, oh, I miss Emily. I do apologize. She's right on the screen next to me. We will just be having a brief hello from Emily in a moment. She is the president of PIBC. So I'll just do a brief territorial acknowledgement before we get going. So I just want to acknowledge that we are gathered here today on the territory of the Tene Nation. So please can everyone just take a moment to feel some gratitude for the lands that we are gathered here on today, and for everyone watching at home, think about the lands that you are joining us from as well. Okay, so I will just quickly just pass over to Emily if she's here. I'm ready to say a quick hello.
Yes, hi. Hi, everyone. I can't see you, but you can see me. I just wanted to give my greetings today. I'm actually in Prince George, but I wasn't able to be there in person because I have another online meeting I have to run to at 1. But I am in Prince George. I have a soft spot for the North. I lived in Fort Nelson for 5 years, mile 300 on the Alaska Highway. So reminds me of home, or one of my homes. And I just wanted to say hi. We're really excited. This is our first regional PLN event. And we had our first online one last week, I think, on the Friday. And we also had a survey where we had 189 responses, evenly distributed from all of the small and medium and large municipalities. So we have heard from you, and we want to hear more from you about what you need with this peer learning network. And with that, I'll turn it back over to Sarah.
Hey, thank you so much. Excellent. So we will be starting with a couple of presentations. You have time to eat your delicious lunch that we have has been put on for you. So we'll be starting today with Deepa Chandran, and she's presenting from us from the town of Smithers on the ADU regulations. So you ready to go, Deepa?
Thank you, Sarah. Hello to everyone. So I'm Deepa Chandran. I'm a planner with the town of Smithers. So I have been working with the town since 2018. This is my 6th year, and I'm here to talk more about the town's accessory dwelling unit, or ADU regulations. And before I start the presentation, I would like to acknowledge that I'm joining you from the territory, the unceded traditional territory of Kidumtan clan and with certain people. So going to the presentation, so I'm just sharing my slides. Oh, there is. Are you already seeing my slide? I'm not quite sure. Can you tell me, Sarah?
No, we can't see them at the moment. They were working earlier, though.
Dave, somebody said it might be.
Okay. Just a second. I realized.
Yeah,
okay.
that's okay. But okay. Dave's also looking into it. Okay, yes, we can see that. Yes.
Okay. Thank you. So this presentation is divided into the following sessions, starting with the definition on ADUs. How did the town used to regulate ADUs in the past? And what were the reasons for updating the regulations? How did we engage with the community as part of the process? And what were the positive outcomes of the updated regulations, the challenges that we have, the next steps? And finally, how does the current ADU regulations align with the small scale multi-unit housing legislation requirements, ending with a brief Q&A session. So what are ADUs? It includes all forms of self-contained dwelling units on a parcel in addition to the primary residence. In some jurisdictions, they also include accessory dwelling units when they are subordinate to existing principal industrial or commercial use. And for the purpose of this presentation and also in the town zoning bylaw, they are limited to principal residential use. So the principal use must be residential to have an ADU. So, and it may not be, as you can see from the image below, it may or may not be attached to the principal building and can take a variety of form. It doesn't have a separate property title, means it will be part of the same parcel where the principal dwelling will be located. So how did the town used to regulate ADUs in the past? So I have to mentioned 2022, that's when the current zoning bylaw and OCP bylaws were adopted. So how did we used to regulate in the past? So in case of carriage houses, it was permitted only in R2 zone, which used to permit only single detached dwelling, duplex and townhouses as principal uses. However, to have a carriage house, the principal use requirement was single detached dwelling. There was also a requirement in relation for floor size that was 90 square meter, and one parking stall was required for every carriage house. Given that carriage house is an auxiliary structure, all auxiliary structure regulations were applied to carriage houses as well. This was applicable in terms of the number of structures, auxiliary structures. That is only one auxiliary structure per parcel. So if the owner had already a greenhouse or a storage shed, they would have had to go through a DVP process. And in case of height, it was 4.9. So if someone wants a 2-story carriage house, they will have to go through a DVP process for height. And the same issue was there for parcel coverage. The maximum parcel coverage for all auxiliary structures was 10. And even in R2, which permitted even townhouse, the maximum parcel coverage was 40%. And there was another restriction where there is an existing secondary suite, or if that parcel already had a home occupation, the owner cannot have a new carriage house unless they go through a site-specific zoning amendment or a DVP. And finally, every carriage house also needed to require a form and character development permit prior to building. In terms of secondary suites, they were permitted in multiple residential zones. However, the principal requirement was single detached dwelling. In terms of floor area, it was limited to maximum 40% of the entire principal building area. And there was a restriction of one secondary suite per parcel. Similar to carriage house, if there is a carriage house or a home occupation on the same parcel, a secondary suite was not permitted. The maximum coverage permitted in all the zones that permitted carriage house was 40%, and one parking stall was required for every secondary suite. So what were the reasons why we thought of updating the ADU regulations? The first reason was limited flexibility in site and building design, which was evident from the number of DVP applications that we were getting. And the second thing was need for OCP and zoning amendment. For instance, if someone from R1 single detached dwelling zone wanted to have a carriage house, they had to go through both an OCP zoning amendment, taking extra time and resources. And this is sometimes this can even discourage the creation of carriage house, especially if someone is not so familiar with the development approval process. The third issue was development permit, the form and character DP requirement. That was also a barrier. So all these were contributing to higher project costs, delay in construction, and less predictability in the creation of ADUs. So there were 3 favorable factors that supported ADU update. update. So the first one was Provincial Building Code update, which happened in late 2019 when the building code was amended to permit secondary suites in townhouses and duplexes in addition to single detached dwellings. And the second factor was increasing popularity of ADUs as a mortgage helper. And finally, the local housing need. So currently 48% of the rental stock, they are from secondary rental market, and ADUs form a significant component part of that secondary rental market in Smithers. So this is what we came up with after the update process. So on the right, on the left, you can see the previous ones, and I have struck down the ones that were repealed. And on the right, you can see the ones that were added in green. So you can see that there were several components that we retained even after we updated the zoning bylaw. This was in relation to the single detached dwelling use. That was the principal use requirement, and also in case of parking stall and maximum floor area. But there were a couple of areas that that had significant amendment. The first one was zone restriction. Currently, carriage houses are permitted in all residential zones except mobile home park zones. And the second difference came in the way how the town regulates auxiliary structures at this point. So in the past, it used to be a combination of the numbers as well as percent parcel coverage. And currently, it's regulated purely by floor area, maximum floor area per parcel, depending on the categories, the size of the parcel. So, and again, a carriage house is not included as part of that floor area calculation for auxiliary structures. So making it further easier for building one. And the other requirement, other change was increasing the height from 4.9 to 6 meter, permitting more design flexibility. And unlike the past regulation, currently we don't have restriction on carriage house construction if there is a secondary suite or home occupation on the same parcel. Similarly, the requirement for form and character development permit for carriage houses, it was also removed from the OCP. And finally, to permit additional densification, we also increase the density parcel coverage limit in our R2 zone from 40% to 50%. However, it remained the same for single family, single detached dwelling zone at 40%. So in case of the secondary suites, there were again substantial changes. The only thing that remained the same was the principal parking requirement. It's still at 1. And in case of the principal use requirement, if it had to be single detached dwelling in the past, now it can be permitted in on parcels that have duplexes and townhouses as well, completely aligning with the building code requirement. There is no floor area restriction. It used to be 40 in the past, and now a parcel can have more than one secondary suite, depending on the principal use. If it's a duplex building, it can have up to 2. If it's a townhouse, it may be 3 or more. So similar to the carriage house restriction, so if there is a carriage house or home occupation, it is not a reason to restrict a new secondary suite creation on that parcel. So increasing the parcel coverage in the R2 zone from 40 to 50 further made it easier. However, as I said, it remained the same for single family zone. So how did we do this update process? How did we engage with the community? So as I said earlier, this was part of the zoning bylaw OCP update process. So we thoroughly reviewed the zoning and OCP regulations that are related to ADU creation, and also reviewed the nature of development approval applications that we received in the past, which indicated that a substantial share of these applications were some or the other way related to ADU creation, indicating the need for update. And we also reviewed good planning practices from across the province and from other communities in Canada as well. So it was an 18-month-long process during which we consulted the community at various points. The Advisory Planning Commission was the lead in the zoning update process, while we had a separate advisory committee for leading the OCP update process. Public education was a key component throughout, especially with the Smithers is a small northern community with 5,300 people. So it's highly suburban in terms of neighborhood character. So there is always this resistance to change when we start discussion about densification. So public education was a big component, and towards the end of the process, we received mostly positive feedback from the community. However, we also realized that information overload was an issue. Going to community with 2 large planning documents, OCP and zoning bylaw, and people always had this difficulty to completely understand, digest the depth of this information or the implications of the proposed changes. The major concerns identified with the proposed ADU regulation changes were loss of community character, infrastructure capacity constraints, loss of privacy, snow removal on lanes, and traffic safety issues that is due to the increased ADU creation. Although town knew that infrastructure can be a barrier in future, no new infrastructure analysis studies were conducted before the OCP and zoning bylaws were amended. This was based on the understanding that even after the ADU updated regulations will be in effect, we are not going to get a flood of these applications within the next few years. And also within that time, town will have the time and funding available to undertake necessary infrastructure analysis studies and also improvements. So the updated regulations, what were the positive outcomes? As there is very limited requirement of going through this development approval process, there was more predictability in the creation of ADUs. Flexible site and building design process contributed to attractive and innovative design solutions. All this directly benefited property owners who had to spend less time and money on these approval procedures. We also noticed that owners were interested in repurposing auxiliary structures into ADUs, for which there are pros and cons, which I will mention in a moment. Something that happened and side by side was reduction in development approval applications, contributed more time available for long-range planning projects, policy development, and grant submissions. And another positive thing that happened along the OCP update process was addition of minor variants and delegated authority provisions in the development procedures bylaw, further expediting the ADU approval process. All these we are anticipating this will eventually contribute to the housing diversity and rental housing stock. This is too early to come up with a trend. Like it's been only 1.5 years since the updated regulations were in place. However, we are getting more applications for carriage houses from zones that were previously exempt from carriage house, where carriage houses weren't permitted in the past. So this is an example of a recent development. So as you can see on the left, this was a heavily underutilized parcel with a tiny log house for several decades. And now it has been, with the updated regulations, the parcel has been developed into to accommodate 3 duplex buildings containing secondary suites, altogether creating 12 new rental rental units. And the value has to be understood in given that Smithers also has a almost zero rental vacancy rate. So what are the challenges? What are the next steps? The challenges are the need to maintain the balance between community character and residential densification impacts. To a large extent, these expectations were set in the zoning bylaw in terms of whether it is in terms of parking requirement or setbacks or the location expectations. This was already set. Increasing pressure on municipal infrastructure that I had explained, like the various ways people were concerned, whether it was snow removal or traffic, or even improvements to existing sewer, water, or sanitary networks. Enforcing BC building code requirements associated with building use conversions. As I said, there are people interested in converting the existing storage structures or other structures, auxiliary structures into carriage houses, but at the same time, it poses safety issues as well if they are not done in compliance with building code. So we have to keep an eye out looking for this kind of conversions. Need for other policy or bylaw amendments. With the increased ADU creations, there is more lane traffic and there is more demand for snow removal on lanes. So we will have to come up with more policies or bylaw amendments to address these issues. So unchanged parking and landscaping requirement still remain as a challenge in some cases, especially if the parcel is smaller than the current minimum requirements or they are skinny. Public education is still a big component of the new regulation. We still get a lot of phone calls from upset property owners who are complaining about their neighbor building a carriage house, because if in single family zone they are not aware, and also like people are concerned about privacy. If someone is building a two-story structure, they want the town to notify, but given that it's already in the zoning bylaw, there is no such requirement. So this is a constant education process. So what are we going to do next? There are two steps. Firstly, undertaking infrastructure capacity modeling studies to evaluate the current capacity and projected need. And this will be, we are considering allocating a portion of the funding, a portion of the 175,000 that we have received from province through local government housing initiative program to undertake one such study. And the second major component is investing in making actual infrastructure investment improvements. So a good amount of this funding, we are hoping that will come from the recently approved Northwest BC Resource Benefit Alliance. So the Northwestern communities have been allocated with 250 million to spend over the next 5 years on infrastructure improvements and planning. So a good amount of funding will come from that source. So how does the current legislation, the small legislation, align with how does the town's zoning bylaw align with the small legislation? So we understand that there are more amendments required. Currently, we permit 3 units, but it must be increased to 4 to meet the small requirements. And there may be more amendments required to reasonably accommodate small needs. These are in terms of parcel coverage, housing forms permitted, parking, landscaping requirements, and simplifying development permit regulations for multi-unit residential developments. Here comes the end of my presentation. Thank you very much. I'm here to answer any of your questions.
And any positions.
Hey, thank you so much, Deepa. That was so interesting to hear. I actually work as a development planner and do a lot of ADU rezoning. So it was really good to hear how you guys have been tackling that in Smithers. That's really interesting. In terms of the Q&A, it might be a bit tricky to do it with everyone in the room, but definitely people on the chat, if you're happy to be joining us on the Zoom call, please feel free to leap in there and get your questions into Deepa while we have her, because she sounds like she has a wealth of information on this topic. So thank you so much for that. If I can just get you to finish sharing your screen when you're ready, that would be fantastic, because we have our next presentation to go to, and also a round of applause never really works on Zoom, but a little round of applause for Deepa.
Thank you, sir.
No, thank you. And yeah, thank you again for giving your time to be here today. Excellent. And so, yes, we will have to move on to our next presenter. So we have with us Guy Patterson from Young Anderson, who's here to talk to us a little bit more about the legal side of all these provincial questions. Yes, and I believe he will be able to do a quick Q&A with people in the room as well afterwards, or on Zoom if you can write him in the chat. So when you're ready, come on up, Guy. Stuff.
Got a lot of props here. Okay, hi everyone. Thanks for coming. Thanks for having me, etc. So I was asked to speak about hazard development permit areas, servicing constraints, housing agreements, and exemption/extension requests in as it relates to, I think, what's broadly referred to as the new housing legislation. So if you didn't sign up to hear about those topics, you can leave now. But you don't have to leave now. So I'll try to make a few general comments maybe before I deal with those specific topics. And then I think my understanding was that I was only meant to speak kind of officially for 10 or 15 minutes or so, and then it was supposed to be more Q&A. So I will try to keep my introductory comments brief, and then I'm all yours, and feel free to interrupt me at any time. And if you don't have lots of questions, then you'll just be stuck with hearing me talk more. So that's an invitation and an opportunity to ask me the questions you have. And of course, it's helpful to me to try to make my comments more relevant if you do pitch questions. And I think the same goes for the people in the online audience, assuming you can hear me. I think you can put into the chat, and maybe Dave's going to moderate that as well. Okay. So, well, one thing I will say is when we say new housing legislation, I think generally we're talking about sort of these three new bills that were introduced in the fall, 44, 46, and 47, I think the numbers are. But I think the one that's probably most relevant, and really the only one I'm going to specifically be focusing on, is Bill 44 that implements the small scale multi-unit housing requirements and specifically zoning changes. I wasn't going to say anything about the transit origin area stuff or the amenity cost charge stuff, but open to questions on those topics if you have any. The other kind of general introductory comment I wanted to make is that the big sort of remarkable change that's introduced by this Bill 44, these Bill 44 provisions in the LGA is an obligation to exercise the zoning power in a certain manner. Like, that's kind of like a radical new thing that the province wasn't typically doing in the past, and certainly not in such an aggressive wholesale way, right? There's marching orders for the manner in which the zoning power must be exercised. And the implications of that obviously are pretty far reaching. But I think kind of maybe as a little counterpoint to that observation about sort of the radical nature of these changes is the point that the only power that the province is saying must be exercised in a certain way is the zoning power, right? The province hasn't, with an exception that I'll mention, it hasn't touched other Part 14 powers or other powers that local governments have outside of Part 14 and even outside of the Local Government Act. For example, community charter service regulation powers and other things like that. So while I think, especially as planners, we typically think about zoning as like the kind of the critical moment in the development, approval, and regulation process. It is only, one hurdle. It's only one step in the development process. And I think, in the context of the questions that I was asked to discuss, DPAs, servicing constraints, housing agreements, we have to remember that those things are further kind of layers in the local government regulatory framework that, again, subject to what I'll say in a minute, are at least arguably not affected, not upset, not interfered with in the same kind of radical way that what the province has done with the zoning power. Yeah. So the real change obviously is to the zoning power, and then there's these kind of incidental effects on other powers, but those other powers still exist. And I think this is just my attempt at clairvoyance that planners and other municipal types it'll become more important to understand sort of some of the nuances of these other powers and how these other powers can and should be used now that the zoning power has been, at least to a certain extent, taken away. Like I said, the main event here is the new section 481.3. Pretty sure that's the new section number that appears now in green text if you go on BC laws and look at the Local Government Act. And that's the section that says, especially sub 2, a local government must permit the use of land, buildings and structures and a density of use required under this section. So must permit. And the next one, must exercise the powers under section 479, the zoning powers to permit, right? So those are kind of the marching orders. You must now do these things in the way that the province has said. So that, again, in a sense, the province is rewriting zoning bylaws for local governments. So you can thank them for that, which is, again, it's not a thing that they did before. And then as sort of a caveat to my other suggestion that the only power that's really been interfered with is the 479 zoning power. There's this new 457.1 that imposes limits on the use of Part 14 powers as well as Part 15 powers, which is heritage. And it says some of those powers must not be exercised in a manner that unreasonably prohibits or restricts the use or density required to be permitted under 481.3, right? So there's must exercise zoning powers in a certain way, must not exercise these other powers in a way that unreasonably prohibits or restricts what you have to do with zoning. And those powers are designation of development permit areas, a power in relation to a land use regulation bylaw, which has a particular definition, but does not include a subdivision servicing bylaw, a power in relation to a heritage alteration permit, or a power to designate heritage conservation areas, right? So those powers have kind of been incidentally curtailed by this new legislation. Okay, so that's my kind of overall context statements or comments. And now I'll just try to get into these 3 or 4 specific things that I was asked to speak about: the hazard DPAs, the servicing constraints, the housing agreements, and the extension exemption requests. So, and I'll try to keep this part brief, but hazard DPA. So, like I said before, the DPA power still exists, right? The only change is that it can't be used in a manner that unreasonably prohibits or restricts the densities that you have to allow. And I think it's probably safe to say that in the case of a hazard development permit area designation, it would be hard to imagine where there's an identified hazard that it would be unreasonable to restrict development in response to that hazard, right? I think what the province had in mind more in this case is layering on a bunch of what the province would think of as unnecessary form and character guidelines in respect of the additional multifamily units that are supposed to be allowed. And I think, as we just heard from Deepa there, they started out with a DP area for some of these additional small scale multi-unit, and then they decided to kind of claw back on that. So they've already figured out that maybe development permits aren't always the best tool to add on and layer on to the multi-unit housing that they were already working on. So anyway, I don't know that the province was really imagining a hazard DPA as necessarily being an unreasonable restriction on use and density if there's an actual identified hazard, but that's not spelled out in the legislation. Anyway, the hazard DPA power, designation power, still exists. And so existing designated hazard DPAs are still valid and new areas can be designated. Bill 44 does not change that. There's always been a unique development permit power under the hazard DPA areas where no other DPA area can you use a permit to restrict density or prohibit density, but with a hazard development permit, you can. And again, that power still exists. And of course, that makes sense because if there's a hazard that gets in the way of otherwise permitted density, it seems reasonable that you might want to limit or prohibit that density. So again, that sort of the landscape of the hazard DPA designation and the authority to designate and exercise your hazard DPA power is, I would say, even with that 457.1 no unreasonable restriction aspect of the legislation I mentioned, even with that, I think it's probably still safe to say that the hazard DPA power is basically unchanged by Bill 44. in fact, it might have become even more important to pay close attention to that power now that potentially additional density is being required to be permitted in areas that might be more challenging for extra residential development. And then there's also now a very specific exemption in the regulation, because the new legislation authorizes the government by regulation to do certain things like create extra exemptions. And it says none of those requirements to add extra housing units apply if the following requirements are met. 1, the land is subject to a hazardous condition. 2, development to permitted density would significantly increase the threat or risk from the hazard. 3, the threat or risk cannot practically be mitigated. And 4, the local government has a report from a qualified professional certifying the matters set out in A and B, but not certifying the matters set out in C. So A and B, where there is a hazard and development to permitted density under zoning would significantly increase the threat or risk from the hazard. There's no need for an application for that exemption. It just exists in the regulation. It's there. If you've got the report certifying the necessary things, then the exemption is there, and those sections that would otherwise require you to add density on those lands don't apply. Okay, servicing constraints. Again, this is a classic example of how I think we often think that zoning is the only hurdle, and we get nervous about somehow being obliged to issue building permits for extra density where the servicing is not available. And in my opinion, that's just not the law of BC. It never has been, and it is not now. That's just my opinion. That opinion of mine is reinforced, I think, by a couple of provisions in the legislation. One of them that says in 481.4 that sections 481.3, 4, and 5 don't apply to land that is not connected to a water or sewer system provided as a service by a municipality or regional district. That exemption doesn't apply to the first step of extra density that you're obliged to authorize in 481.3. And so that's the obligation to allow one additional housing unit, either as an attached or detached suite. So that's 481.3. You must allow one extra housing unit on land otherwise zoned for detached dwellings. But the next steps where you have to allow 4 and in some cases up to 6, I don't know how much frequent transit service there is among the people who work here, but you still are, if you're in the 5,000 population or in an urban containment boundary, you have to allow the 4 housing units, or 6 if close to transit, frequent transit. But those, the one extra unit, you have to allow it. But the next 2 steps of either 4 or 6, they don't apply if the land is not connected to a water or sewer system provided as a service by a municipality or regional district. So as far as servicing constraints, there's already baked into this legislation an automatic exemption where servicing, what I would characterize generally speaking as servicing constraints exist. So that's in there already.
I hope you're going to talk about this a bit more.
Definitely not.
Because the servicing capacity,
Yeah,
like connected doesn't mean you have enough.
right. That's okay. That's what I'm going to talk about right now. Yeah, at least a little bit. So already in the zoning, in the new zoning arrangement, there is an acknowledgement for no need to add the housing units where not connected. So that's one step in the servicing constraints world. The other thing is that, of course, maybe not of course, but as a matter of law, the building code still applies, even if you don't have a building bylaw, actually, by the way, but most places now will have building bylaws, and the building bylaws will say you have to comply with the code. And the code says, I'm pretty sure any building, residential building anyway, requires potable water, whether on a well or by connection to a system. And when there is a system, typically the local government will have a rule that says, if we have a system, you've got to connect to it. So again, if you need potable water to meet the code, and there is no potable water available because our system has no more room to add you to connect you to the system, then that might be a servicing constraint that stops someone from getting a building permit, even though the zoning was changed to authorize the density, the extra density for the extra unit. So that is where your service regulation power, which is not a power under the Local Government Act at all, but it's a power under the Community Charter to regulate in relation to services, likely, and this is, you know, kind of likely, this is a very general statement, but likely, and especially if it's in your bylaw, but you probably don't have an obligation to allow a new connection to your water system if you don't think there's enough water for that connection. You know, you want to make sure that your water service bylaw says that. But in my view, it's a valid provision of a water service bylaw to say that if we don't have enough water, we don't have to connect it to our system. So basically the same goes for sewer. And again, the building code requires, in most cases, some form of sewage disposal. And I think the building code says if there's a public sewage system, you have to connect to it. You can't do a septic. Anyway, so the code requires potable water. In some cases, it requires water for firefighting purposes. And I think in all cases requires sewage disposal. So that's all in the building code, no matter how many units the zoning bylaw says you can have. And so those are just a few general comments about servicing constraints and the very, I think, important focus that it places on the local government's authority to exercise in relation to exercise its authority in relation to a service that it's providing. So, if not connected to a service, then certain exemptions apply automatically under the legislation. And then, of course, there is a question about what does it mean for land to be connected to a service? Does that mean there has to be a pipe on the street adjacent, or does it mean there has to actually be, you know, a service connection to that pipe? I'm not going to venture any opinions about that point, but I don't think the province is suggesting that we should be adding housing units where insufficient servicing capacity exists. What the province is suggesting, if you kind of if you look at the small scale multi-unit housing manual, what they're trying to say is basically, well, we don't use as much water and sewer water as we used to, and there's all these great ways you can reduce water use, so you should probably just connect them anyway. I mean, that's maybe maybe an unfair generalization of what's in the manual, but the manual definitely, it sort of glosses over this problem and tries to pretend it doesn't exist, basically. Which I think is maybe an optimistic view of the reality, at least of some servicing constraints in some communities. You know, but bottom line, I think no one's suggesting that if you actually legitimately don't have servicing capacity, that you still necessarily have to allow new connections. That's just my real kind of loose view.
I've heard Minister Callan where it's a little bit different. Because we're really clear you can't use that as an excuse. They're not allowed density, this sort of blurring. And I think the challenge is we've got a lot that's for 40 years had a sewer and a water connection. So it's got a connection. We have to allow this density. We can't not issue them permits to put in more ADUs, even if our system capacity's got deficiencies.
Well, I don't know if I agree with that.
You gotta do something to increase the capacity of your system, but you can't use that as the excuse to deny the permit.
Well, I mean, look, I mean, my view is if you have a sewer or water or both regulation bylaw, and it sets out clearly the circumstances in which a person is entitled to a new connection, and the person can't meet those requirements, I don't get it.
But the issue here, I think, is that it's not a new connection. It's because it's a lot with the house sitting on it built in 1972 that has a sewer and a water connection.
Well, I've read bylaws that say a connection, you like one connection can't serve 4 units.
Well, that might be the thing. You might need to have your bylaw.
That's the thing. You gotta look at your bylaw.
Let's say your bylaw regulates that piece of connection.
I mean, that land is connected. In that case, the land is connected. I think there's no argument there, right? But again, I don't know that, and look, it might be awkward for sure. And maybe your bylaw is not very helpful to you because it doesn't specifically tell you what you want it to say. But I still say it's going to be hard to convince a judge of the BC Supreme Court that you should be going around connecting all these new units where you don't have enough supply. I think the problem is that I think in many cases, there's like a knee jerk. Oh, don't have supply, don't have supply, don't have supply. And the problem is kind of saying like, really? Are you sure? Like, prove it, right? And that's a real issue for sure. You might be, you know, having to get your engineers to sharpen their pencils. Absolutely.
If
I
you
think
have
that-
engineers on staff.
Yeah.
They can work consultants.
Look, if,
I got one.
nobody knows. And if you're sort of unreasonably denying extra connections because you don't have good evidence about capacity, like it's going to be awkward for sure. And I'm not running around saying like, perfect, we can stop development with these like, bogus servicing constraint allegations. I'm just saying that if you have good evidence, compelling evidence that extra connections are going to, destroy your system or whatever, or, pollute the nearby watercourses because of sewage flowing in the streets. I don't think that this legislation is telling us that that's, the required result.
I think one lesson is, and Deepa mentioned it, there's other bylaws, there's other pieces that need review. The sewer and water bylaws, I don't know, this has been updated recently a little bit, but it's like a 19 bylaw. And a recent amendment was made to bring some rates in it up to date because they were 1993 rates. But now in light of this legislation, maybe there needs to be something in those bylaws talking about when you add a third or fourth unit on a lot, you have a requirement to prove the services capacity.
I mean, we've historically relied on zoning as the moment to do all that work, right? And so now maybe that work has to be done other than at the zoning stage.
And those bylaws were written with zoning that allowed non-residential.
Yeah. And maybe the system was designed also with that zoning in mind too.
And that's very important to asset owner.
Anyway, so those are my comments on servicing that I could be totally wrong about. But okay, so housing agreements, I guess, typically, or like, I'm not sure what order to say this in, but there still is authority to enter into housing agreements. Existing housing agreements are still valid. Nothing in the legislation changes that. Typically, a housing agreement, and arguably it's not really within the scope of a housing agreement to regulate density, right? A housing agreement typically regulates occupancy of units that are otherwise authorized by zoning. And so, you wouldn't be looking to your housing agreements as a way to sort of to regulate density, but you can continue to use housing agreements where the owner is willing to enter into one as a way to regulate occupancy and price of housing units that do get constructed. Probably the big asterisk, I guess, in as regards housing agreements is in relation to the prohibition against what are being called conditional density rules. That comes up in 481.5. And that says, first it defines this term conditional density rule, which is a density rule established under 482 sub 1, which is the authority to create a density bonusing scheme, right? Where you have a base density and then you have extra density in exchange for the provision of amenities or meeting certain conditions. One of those conditions can be that the owner enter into a housing agreement. So there's kind of like two main ways that we get these housing agreements, that we extract these housing agreements from owners or force them to agree. One is just at the rezoning negotiation stage, and the other is it's through a density bonus scheme, right? So until this new legislation came in, we could have had a scheme that says you can have one dwelling unit and you can have a suite if the suite is restricted in rent and restricted to local employees or something. That could have been a valid density bonus scheme in a bylaw. But now it says that you can't establish a conditional density rule for the purpose of achieving the minimum number of housing units required under the 4 or 6 unit obligations, except in respect of the 6 unit obligations, you can have density bonus conditions related to one of those 6. So it's sort of like a weird bit of math and a weird bit of legislative drafting. But the bottom line is it's going to be difficult under this new scheme to use density bonusing for housing units that must be permitted as a way to get those units to be regulated by a housing agreement. So whereas previously you could have said any kind of extra housing units can be treated as a density bonus in exchange for housing agreements, basically that you've kind of lost your bargaining power in that sense under most of the housing units that you're obliged to authorize. But where an owner, for whatever reason, can be convinced or wants to enter into a housing agreement, you can still enter into a housing agreement under all the same legislative provisions. The framework for housing agreements still exists, and existing housing agreements, in my opinion, are not the enforceability or validity of those agreements is not affected by anything in Bill 44. The last topic was exemptions/extension requests. I don't think there's so there are exemptions. I talked about some of them. Some of them are set out in 481.4 and some that are added by regulation, the hazard one in particular. And there's no need, at least that I'm aware of a request for an exemption, right? The exemptions are just there. You either qualify, or land either qualifies for the exemption or it doesn't. But for extensions, so that's where this deadline of June 30th, 2024 comes up. And there's a specific provision that says if you can't meet your obligation and get your zoning bylaw amended in time, this is under the transition provisions in section 780 some odd, that you can apply for an extension so that you can update your bylaw after the June 30th, 2024 date, rather than in advance of that date. And you apply to the minister, and the minister reviews, and basically, and there's certain reasons why you're allowed to, or the basis for the request, and it sets out, it says, in the process of upgrading infrastructure that services the area. Right. So again, there's an acknowledgement, I think, in that section alone that services might not be sufficient and need to be upgraded. Whether you're doing it on your own or not is another question, but it's out there. Or the infrastructure that services the area is such that compliance by June 30th is likely to increase a risk to health, safety, or the environment, or there exists extraordinary circumstances that otherwise prevent compliance. So that's a kind of a wide open invitation, but the circumstances have to be extraordinary. We don't exactly know what that means, but the bottom line is you have to come up with a pretty good excuse for not complying by June 30th, 2024, in which case the minister can give you notice that the extension request is refused or granted. Yeah, so anyway, that's just if you think you can't keep up to these aggressive timelines for zoning amendments, then you can apply for an extension and try to get a break. Or you could not apply for an extension and see what happens. Oh wait, this is being recorded.
That was my question. I can't remember, does it say what happens if you don't meet the deadline?
I forgot to mention I did want to say at the very beginning, and I won't try to take up too much more time so we can have some more questions, but I did want to say at the beginning that I should have started keeping track of the number of questions I get about how do we comply compared to the number of questions I get, what happens if we don't comply? But most of the questions I'm getting are, how do we comply? Which is maybe a good sign. I don't know. Or maybe no one wants to ask the other kind of question. But some people, of course, can't resist, can't help themselves, but ask, what if we don't comply? And the answer is pretty clear. The minister can order that you comply. And if you don't comply in time, they can amend your zoning bylaw for you. So if you if you want to know what your zoning bylaw is going to look like after the minister amends it, you might want to read the manual, especially the second half of the manual, the small scale multi-unit housing manual. So yeah, that's the answer to what if we don't comply is you sort of you might lose agency over what your zoning bylaw says.
It seems like it's some fairly detailed work to look at an old infrastructure system and try to figure out capacity by neighborhoods. And I mean, if you were going to do it seriously and your infrastructure was built and much infrastructure was, there's no way that you could move that down. I mean, even if I were a zoning bylaw writer consultant, why didn't I do that?
The thankless task.
But that's only one step in it. And I just think that, I mean, the reality of urban and rural servicing information, is like up to.
So you're saying you'll be surprised if the local government has enough information to justify the extension request under the criteria that I mentioned, or?
By what, how would they justify if we don't actually know? Is that a terrible question?
That'll be a little It's a good question. Exactly. I don't know, trying to recognize, especially that this is incremental change. You're not going to see fully much in the uncertainty. But it is like a huge step because object example of what it's been a year and a half for us to update. You know, that is given something about what the ADUs, but just the amount of time that historically put into coordinating engineering and park management and being asked to do it in like 3 months is like a tall order for sure.
Well, and I guess maybe what I would say to that is, first of all, the province has gotten impatient. And second of all, that all that stuff that you thought you had to do before changing your zoning bylaw, they're kind of saying, well, you don't. There's no time for that. But again, what I say is, okay, so now you've taken away the zoning hurdle to development, but there might be other hurdles to development, right? And those hurdles, I don't think can overcome, or they're not necessarily automatically overcome. It's not just a ticket to build a bunch of new development that has no infrastructure to serve it. Now, like I said, there's a real risk that once we unleash the zoning beast, it's going to be a lot harder to deal with those other issues. But it's like, maybe we should, stop spending so much time with our zoning bylaw and start working on our other bylaws, that's just one view.
Okay, excellent. Well, thank you so much, Guy. That was fantastic. I think Guy will be sticking around, so we always have more questions for lawyers. So if any come up, he will be here to help. But yes, thank you so much. Let's give Guy a little round of applause. Yes, excellent. So yes, Guy, wonderful presentation, and thank you again to Deepa for her sharing her work they've been doing over in Smithers. Sorry, I'm from Vancouver Island. The geography sometimes escapes me. Everything's normally just up. So now you're moving into this discussion portion of today. So yes, we really wanted to make sure you had the chance to talk to each other and have a bit of discussion about some solutions or what your community is planning on doing or what you've seen other people doing really well. So we will be kind of splitting off from our virtual attendees. Kenna will be taking care of them to make sure they can also get in and have a discussion in the online format, and we'll be keeping it to us as the in-person section. So